judgment delivered yesterday, April 8, 2025, by the Supreme Court of India, and specifically the two-judge bench, the bench of Justice Pardiwala and Justice Mahadevan, is a historic judgment because it invalidates the arbitrary actions of the governor in withholding assent to bills adopted by, in some cases unanimously, by the state legislature in the state of Tamil Nadu. It finds the governor's action illegal and erroneous in law. It indicts the government for mala fide action. It has even gone so far as to cancel the consequential actions of the President of India on these bills, because the governor, having sat on it for a very long period, going up to 5 years in one case, or governors, and in this governor 2 or 3 years, then virtually tries to kill the bill, and that is not valid because they have held that the governor, as a rule, is bound by the aid and advice of the Council of Ministers. The governor is only a titular head, he is a constitutional head. The governor is obliged to respect the wishes, aspirations and decisions of the people and their elected representatives, that is the state assembly, and then the government derived from the strength in the assembly. So that has been clearly said. It's always made clear in the earlier case of Punjab. The state of Punjab, again the governor was found wanting. He acted wrongly, they have found, a three-judge bench of the Supreme Court. So it's gone as far. And for the first time, as far as I know, they have prescribed timelines that if a bill is sent to the governor for processing, there are only 3 courses open to the governor. One is to give assent immediately, as soon as possible is the word used. Then it becomes law, can be notified. The second course is to withhold assent, but you can't withhold assent for a long period. It's as soon as possible. You've got to send it back with your recommendations or suggestions to the assembly. And if the assembly passes it again or adopts the bill again, it becomes law. Your role is over there. You cannot stop it from after that. In a few very rare cases, particularly cases relating to the power of the Supreme Court, if something comes up, a bill that seeks to derogate from the authority or power of the High Court of the state, then that shall be referred to the President of India for consideration. Not every other bill. And certainly not after sitting on it for a very long period, treating it as dead, and then when the Supreme Court pulls you up in a hearing, you then send it to the President. That has been knocked out. So now clear timelines, 3 months in a couple of cases, 1 month in one case. You've got to act, either give assent, withhold assent and send it back with your suggestions. And if it's adopted with or without your accepting your suggestions, that is what Article 200 says, it becomes law, automatically becomes law. The governor's role disappears after that. It's only a formality. So this has been made clear, and you've got to read it along with other judgments, where in the Bombay case in 1994, the seven-judge bench of the Supreme Court of India held that federalism is part of the basic structure of the Constitution. You cannot amend that part through a constitutional amendment. It is part of the basic structure of the Constitution. And so on. And then they read down the application of Article 356 in that famous judgment, historic judgment. This comes along the same path. First, the Punjab judgment, the judgment in the case of Punjab, where the same controversy or a very similar controversy arose. And now, most recently, and with further features, more specification, establishing a timeline, making it clear that even the President's action will be subject to judicial review. These are the highlights of this judgment, and they speak to its historic importance. Yeah, an interesting feature is, again, I don't know if it's happened before, the Supreme Court of India in this case has pronounced the 10 bills that were withheld by the governor, blocked by the governor, vetoed by the governor in effect. They declare it to be deemed to be law. In one stroke, the Supreme Court has converted 10 bills into acts of the legislature. Immediately it can be notified, it can be gazetted as soon as the official copy of the judgment is received. Maybe it will be today. This can be done. As far as I know, we have not seen this before. It was a very bold action, but a very just and correct action, because you can't make the State Assembly and the people of Tamil Nadu pay for the misconduct of the governor, because they have said he's acted in a malafide fashion. That means you worked against the Constitution. Misconduct is a mild word in this context. They have not used this word, but that's what it is. The governor has not behaved according to the high standards expected of the head of a particular state. And so this governor, I think, has no footing in this state. The only self-respecting, if he has any self-respect, any sense of dignity, the only course open to this government is to apologize to the elected government of the state, to the people of the state, and to tender his resignation, bowing down to this verdict of the Supreme Court of India. That would be, he can save face, he can recover some of his reputation if he does that. And I hope Governor R.N. Ravi will see the wisdom of what everyone is expecting. I saw an interview where the senior advocate, former Attorney General of India, Mr. Mukul Rohtagi, interviewed by Rajiv Sardesai, said this. In his view also, he put it in legal language. This governor should resign. This judgment of the Supreme Court is not just for the benefit of the State Assembly, the government, the elected government, and the people of Tamil Nadu. Its benefits are instantly available everywhere. They have to go through the process or procedure again. It will help Kerala, where already the former Attorney General of India, senior advocate, my friend Mr. K.K. Venugopal, has already initiated the matter. I'm sure the same thing will come there. And then there is a problem elsewhere, where governors are working against the state government, particularly on the matter of processing bills sent to the governor for approval. I think it's going to be of great benefit. It will be a blessing for all the states, particularly opposition states, but even for BJP-ruled states, I think it can help. And for the allies, such as the Honorable Chief Minister of Andhra Pradesh, my friend Mr. Chandrababu Naidu, even though he's an ally of the BJP and part of the NDA, I think he would also, feel very satisfied and pleased with this, because it asserts the rights and privileges of state legislatures and elected state governments, which then send it to the governor. So I think everybody, mainly the opposition parties, but even beyond that, those are in the ruling camp, those in Delhi, I think they will also benefit from that.
Last question, sir.
I think in future the governors should not behave. Mr. Ravi's tenure as governor has been a lesson in what you should not do as governor. And in future, I think governors will be obliged to obey or act according to the strictures and the clear pathway opened up by the Supreme Court of India in this, that you are only constitutional heads, only titular heads. You cannot act as opposition, you cannot veto, you don't have a pocket veto. Your business is not to put roadblocks. Those words have been used in this. So I think, I hope that the Home Ministry, which usually processes this matter, selects better governors than we have seen in the recent period of BJP rule, and also that these governors act in accordance with the dignity of the office, the high standards expected of this office, and it shouldn't be, as somebody said, a race to the bottom. That governor has done it, so I'll go further to the bottom. So I think that's my expectation and hope.